Let's get back after it. We're doing void judgments at the moment. The last video before this was about void judgments. Covered Colorado, New Mexico, Nevada, a couple other states. So if you don't see your state in this video, go to the other video. Oklahoma, the general rule is that a void judgment is no judgment at all. Where judgments are void, as was the judgment originally rendered by the trial court here, any subsequent proceeding based upon the void judgment are themselves void. In essence, no judgment existed from which the trial court could adopt either findings of facts or a conclusion of law. Always want a finding of facts and conclusions of law. Ladies and gentlemen, when challenging jurisdiction, there's a number of ways of going about it. All right? First of all, I used to be one of them fucking wingnuts that used to go in there and go, I'm challenging jurisdiction. That shit doesn't fucking work. Stop doing it. Okay? All right? You challenge jurisdiction by asking questions, not making the statement that you don't have jurisdiction. All right? And how you're going to do it is there are a number of prerequisites these people have to have. But the easiest way to do it is just nailing them on territorial jurisdiction. They're way outside their league. So territorial jurisdiction should always be one of the first attacks you do. Not to mention that the pleadings are unsworn to, assume facts not in evidence, facts not agreed to, requires a legal determination, their pleadings are deficient and insufficient and violate the Sixth Amendment because you have a right to face your accuser. In most of the states, I think all but 3 are notice pleading states, which means nobody has to swear out to anything. And their maritime admiralty jurisdictions using law of mercantile and law of merchant in their private administrative courts. That's what they are. Article 1, Section 8, military fucking tribunals. They don't have jurisdiction if there's no injured party. No injured party, put 2 big middle fingers in the air and say, I wouldn't let you lick the sweat off my taint if you were parched in the fucking desert, you fucking tyrant. You know? It's that fucking simple. It really is. And people go, oh, you gotta be nice and respectful to them. They're thieves. They're lying, looting, pandering, plundering fucking thieves. Okay? Hell-bent on overthrowing the Republican form of government that we the people ordained and created for ourselves. And they're overthrowing it. All right? They're engaged in espionage, mixed war against the Constitution. They don't have their Title V 3331 oath of office. They don't have their Title V 3333 affidavit in support of their oath of office. They don't have the Title V 3332 affidavit that's supposed to be a launch to their oath of office, and they don't have their Title V 33333 anti-bribery statement and affidavit that's supposed to also be allonged and in tow with it as well. All right? Just on that grounds alone, they don't hold office. Okay? Then they don't have the Title 4101 oath of office. They don't have the Title 28 United States Code 453 oath of office for all the officers of the court. They don't have their delegation of authority, letter of appointment, warrant of attorney, grant of assignment, power of attorney from the Treasury of Puerto Rico to even operate outside Washington, D.C. and touch your decedent estates. Okay? That's under Title 26, 6903, 7603 or 7306 on Title 26. All right? To issue the summons, to be in direct contact with decedent estate property. Then under Title 26, 2032 AE 11, they're not even independently bonded with the Secretary of Treasury of Puerto Rico, which is absolutely a fucking prerequisite and mandatory for them to be. All right? They're foreign agents operating on your soil. All this stuff lends to the fact they don't have jurisdiction. They're non-compliant with the Foreign Registration Act of 1938 as amended in 1939, which is also found in Title 22, 611, 612, 613, 614. All right? They don't have a Rule 2 opinion letter from the IRS. They don't have a letter of good standing from the IRS to even do business in the United States. All right? All these things have to be proved on the record to prove they have jurisdiction. They can't just say they have jurisdiction. It must be on the fucking record. So when you say, I need you to produce all these things, so we can establish jurisdiction. We got to establish jurisdiction first. We're going to start with territorial. We're going to go to in personam, and then we're going to go to subject matter jurisdiction. Before we get to any of that shit, we're going to make sure all your guys' fucking credentials are in line. Who's going to indemnify me in case I'm caused harm, damage, loss, or hardship? In the event that somebody's engaged in a simulated legal process using sham pleadings under the color of law, under the color of office, and the color of authority, right? Who's going to indemnify me? Everybody in this room's getting paid, and you jackboot thugs are all operating a private, for-profit, ad hoc corporation using statutes, codes, city ordinances, rules, and regulations. Damn it, I want to see the contract I knowingly, willfully, and intentionally entered into that binds me to your statutory fucking edicts, otherwise known as bills of pain, ex post facto law, bills of attainder, guilty until proven innocent, under your administrative law clerks, administrative law judges, and Administrative Procedures Act. Under the executive branch, because that's where the administration branch is lodged under. It's underneath the executive branch. That's why I'm doing this whole fucking spiel on void judgments, because if you've had judgments in the past, ladies and gentlemen, there's no statute of limitations to go overturn it and get your fucking money back. And if you go watch my other videos, you'll realize how much money's really there. Credits on account, if you will. That's why I'm doing this, to help people out. So we've been through a few states. We're back in Oklahoma. Valley Vista Development Corp. Versus City of Broken Arrow. I'm not going to read all these numbers again. That was an Oklahoma case in 12/06/1988. A facially void judgment may be vacated at any time. Section 1038 provides that the passage of time does not operate to bar a quest to vacate a facially void judgment. Reed versus Reed. 2001, Oklahoma 87, Oklahoma 10/16/2001. The pertinent provisions of 12 OS SUPP 1993, subsection 1038 states, a void judgment, decree, or order may be vacated at any time on motion of a party or any person affected thereby. Title 12 OS 1971, subsection 1038 provides that a void judgment may be vacated at any time on motion of any person affected thereby. This means anybody can do it. All right? If you read a case and you know it's bogus and it's bullshit, you can do a collateral attack on it and you can overturn that motherfucker. You don't even have to be in the same damn state and you can do it. All right? Because a void judgment can be challenged at any time, in any court, in any jurisdiction. The issuance company claims that it has never asked that the default judgment be declared void, merely that the judgment should be ignored since it is a nullity. Defendant's argument is supported by the general rule that a void judgment is no judgment at all. Lee Clare versus Call Hims, 106, Oklahoma, 247, 233, P. period, 1087, 1925. A void judgment is, in legal effect, no judgment at all. By it, no rights are divested from it. No rights can be obtained. Being worthless in itself, all proceedings founded upon it are necessarily equally worthless and have no effect whatever upon the parties or matters in question. A void judgment neither binds nor bars anyone. All acts performed under it and all claims flowing out of it are absolutely void. The parties attempting to enforce it are trespassers. Ooh, I like that. I like that one. Oh, I'm going to commit this one to the spank bank right here. This one's got to be locked into the memory hardcore. And guess what? You can use this by invoking Article 4, Section 1, full faith and credit. This is a nice one. I like how it says that when they continue to persist on, it can only be equated to a trespass. High versus Southwestern Insurance Company, 520 P. period 2D 662 1974, Oklahoma 35, Oklahoma 319, 1974. A void judgment may be vacated at any time. Title 12, Oklahoma Statute, Sections 1038, D. Judgment may be vacated at any time. Churchill versus McGee, Oklahoma 323, P. 2D 339, and may be vacated at any time on the motion of any interested party. State versus City of Tulsa, 153, Oklahoma 262, P. 5P. 2D 744. Void judgment cannot constitute res judicata. Denial of previous motions to vacate a void judgment could not validate the judgment or constitute res judicata for the reasons that the lack of judicial power inheres in every stage of the proceeding in which the judgment was rendered. Bruce versus Miller, 360, P. 2D 508, 1960, Oklahoma 266, Oklahoma 1227, 1960. And this brings up another good point. You can challenge the validity of the proceeding at any time, and if you're denied, you can immediately go into an interlocutory appeal and send it up to the higher court based upon constitutional issues, the constitutionality of what they're doing, all right, and void their judgment. You start bringing up Article 1, Section 8, Clause 17, Article 1, Section 8, Clause 13, Article 1, Section 8, Clause 10. You start bringing up that shit, poof, abracadabra. So long as you didn't cause any harm, damage, or loss to somebody who's actually making a claim saying that you've done them a wrong, poof, case be gone. A void judgment is one that is void upon the face of the judgment roll. Capital Federal Savings Bank versus Bewley, 795 P. 2D 1051, Oklahoma 1990. The judgment roll has been defined to include the petition process, return, pleadings, reports, verdicts, orders, and all other acts and proceedings of the court. Mayhew versus Mayhew, 706 P. 2D 890, Oklahoma 1985. A void judgment may be attacked at any time, whereas a judgment which is only voidable may be successfully attacked only if the requirements of 12 OS 1981 subsection 1031 are met. 12 OS 1981 subsection 1038, Capital Federal Savings Bank versus Bewley Supra. Here it is clear from the face of the order confirming sale that appellant's due process rights were violated. Thus, the order confirming sale is void and on its face, and the trial court was without jurisdiction to enter such order. The trial court's judgment is reversed, and this matter is remanded for further proceedings consistent with this opinion. Federal Deposit Inc. Institution Corporation versus Durkin, 810 P. 2D 1038, 1991, Oklahoma Civil Appellate Division 39, Oklahoma APP Appellate Division 3, 0430, 1991. Any interested party may move to set aside a void judgment. There it is again. Any interested party, whether directly or indirectly. High versus Southwest Insurance Co., Oklahoma 520 P. 2D 662, 1974. This means if you've got aunt, uncle, cousin, mom, dad, sister, whatever, in jail, you can turn around and do a collateral attack on their void judgment knowing what you're learning here, okay? Knowing that they don't have all the proper prerequisites to even be hearing the matter, all right? They're outside of their territorial jurisdiction. The state cannot be a victim, ladies and gentlemen. All this bullshit falls underneath Title 27 CFR 7211. All crimes are commercial, which means everything is civil. All right? They're usurping power otherwise not delegated to them. They're hoodwinking you. It's crazy. It's craziness. A different statutory rule applies when the judgment sought to be vacated is alleged to be void. Under the provisions of 12 OS 1971, subsection 1038, any party affected by a void judgment has an independent claim for vacation. It may seek vacation at any time. Gent versus Brown, Oklahoma, 280 P period 2D 1005 1008 1955. This goes for all of those people out there that are allegedly hemmed up on felonies. You should go back there and overturn that thing, make it a void judgment, and then do a collateral attack on all the securities and dividends and derivatives and rents, profits, and proceeds created from the bonds. All right? South Carolina, a void judgment is one that, from its inception, is a complete nullity and without legal effect. Thomas and Howard Co. versus T.W. Graham and Co. 318, South Carolina, 286, 291, 457, S period, E period, 2D, 340, 343, 1995. The definition of void under the rule only encompasses judgments from courts which failed to provide proper due process, or judgments from courts which lacked subject matter jurisdiction or personal jurisdiction, and they're forgetting, again, the territorial jurisdiction. But here, they always deny you due process of law, because why? You're going to ask them, what's the nature and cause? And they're going to just start reading a bunch of shit off a piece of paper, a bunch of codes. All right? Well, that shit, that numeric shit, is not English. All right? A code is something that has to be deciphered. All right, we need the plain language under the plain language doctrine. What exactly is going on here, and who exactly is making the motherfucking claim? Because they're all using false and fictitious unregistered business names to engage you in an artifice and a scheme through a simulated legal process with sham pleadings that are unsworn to, unverifiable, by unknown names, by false and fictitious names, by unknown, unregistered, unidentified agents. You take that little bit that I just said and slap that on a document and attach it to any case and turn that sucker void. Just think about that for a second. You got an unidentified, unknown, unnamed agent and agency. And how do we say that? Because they're never using their full legal name. We don't know who the fuck they are. All right? They're never using their proper name. And they're bringing it forward in by using an entity that is unknown, unidentified, unverified. We don't know if it's got a DUNS number, an EIN, a TIN, an ITIN. We don't even know that they're registered with the Secretary of State to even do business. Because the state of Texas, the state of Nebraska, the state of Colorado, all that shit, everybody sees the Constitution and goes, oh, that's their charter. No, it's not. It's not their charter. Make them produce their shit. Where's your articles of association, articles of incorporation, corporate charter and bylaws? Where's your insurance policy? Think about that for a second, guys. Think of all this information that nobody ever brings up. You start bringing up all that stuff, they're just going to throw the case. They don't want to fucking deal with a person like you, a man or a woman like you. That's trouble. Somebody can go to prison for a really long time. You're asking way too many hard-hitting questions. They just want to get the fuck rid of you. And do it before court. Do it in paper document form. And have a disinterested third party either deliver it upon them, serve it upon them, mail it to them, and tell them, hey, in 21 days, if you don't have fucking answers for each and every one of these fucking points, I'm sending each and every one of you personally, in your individual personal capacity, which you're liable for, an invoice for wasting my precious valued fucking time commodity in an artifice and a scheme. And I'm going to default you on it. And it might be for tens of millions of dollars, just to let you know. But don't worry, if you're not doing anything illegal, you're not engaged in mixed war against the Constitution, you're using your full legal name, you're operating under your oath of office, where you signed your full legal name to your oath of office, and you have the Title V 3331 oath of office, the Title V 332 affidavit that's alleged to it, and you met all the requirements for filling the office, you have nothing to worry about. Proceed on. Watch how quickly they all just go, I'm recusing myself. The state hasn't met its burden. There's some technicality. Fuck it, we're throwing it. Because remember, equity won't allow a statute to be used as a cloak for fraud, which is exactly what the fuck they're doing. And this guy from California keeps calling me. I'm going to block his number. That shit pisses me off. I'm in the middle of something. Or judgments from courts which lack subject matter jurisdiction or personal jurisdiction. McDaniel versus U.S. Fid and Gar Co. 324, South Carolina, 639, 644, 478, S period E period 2D, 868, 871, CT period, APP period, 1996. It is fundamental that no judgment or order affecting the rights of a party to the cause shall be made or rendered without notice to the party whose rights are to be affected. All right? If you weren't given proper notice and opportunity, the whole process is void. For what? Denial of due process of law. That's under the 4th and the 5th Amendment. It's not the 14th Amendment. It's the 4th and 5th Amendment. Tyrone Fed Savings and Loan Association versus Phelps, 307, South Carolina, 361, 362, 415, S period E period 2D, 397, 398, 1992. Generally, a person against whom a judgment or order is taken without notice may rightly ignore it and may assume that no court will enforce it against his person or property. The requirements of due process not only include notice, but also include an opportunity to be heard in a meaningful way and judicial review. Grains versus Ordine, 234 U.S., 385, 394, 1914. The fundamental requisites of due process of law is the opportunity to be heard. South Carolina Department of Social Services versus Holden, 319, South Carolina, 72, 78, 459, S period, E period, 2D, 846, 849, 1995. Now we're on to Texas. We just did South Carolina. We did Oklahoma. Now we're on Texas. In prior videos, we touched New Mexico, Colorado, a couple other states. Texas. Double record this series of lives, Derek says. Yeah, I'd go back and download those motherfuckers because you know Facebook ain't leaving those things up. I'm dropping all kinds of information for you guys to kick some ass. It's time. Judicial action, this is for Texas. Judicial action taken, and again, when I say it's just, this is for Texas, understand that under Article 4, Section 1, the full faith and credit clause, you can use all this stuff. You can use this from every fucking state and drag it in to whatever state you're in. But what I keep stressing is the territorial jurisdiction, ladies and gentlemen. I keep stressing that. Judicial action taken after the trial court's plenary power has expired is void. See State Ex Rel, Laddie versus Owens, 907, S period, W period, 2D, 484, 46, Texas, 1995. See also Mapco Inc. versus Forrest, 795, S period, W period, 2D, 700, 703, Texas, 1990, defining a void judgment as one rendered when a court has no jurisdiction over the parties or the subject matter, nor jurisdiction to render judgment, or no capacity to act as a court, or no territorial jurisdiction. I'm going to add territorial jurisdiction to every last fucking one of these things. A party affected by void judicial actions need not appeal. State Ex Rel, Laddie, 907, S period, W period, 2D at 486. Now, you need not appeal, but you need to put all those jackasses on notice. Hey, your order is void. All right? It's not just voidable. I'm telling you, it's void. I don't consent to your jurisdiction. You didn't inform me of the nature and the cause. You are violated the 7th Amendment. Fuck off. It's void. 907 S period W period 2D at 486. If an appeal is taken, however, the appellate court may declare void any order the trial court signed after it lost plenary power over the case. A void judgment is a nullity from the beginning. From the beginning. So if it's nullity from the beginning, what the fuck do you got to fucking appeal anything for? Or put a motion before the court for? All right, it's void from the beginning. Tell them to fuck off. All right? Or tell them to fuck off, and if they don't fuck off, you're going to send them an invoice, and 2, then you're going to have them before the Judicial Committee Review Board at the Congress to see if we can put them in Guantanamo Bay for mixed war against the Constitution. A void judgment is a nullity from the beginning and is attended by none of the consequences of the valid judgment. It is entitled to no respect whatsoever because it does not affect, impair, or create legal rights. Ex parte Seidel, 39, S period, W period, 3D, 221, 225, Texas Criminal Appellate Court, 2001. Only void convictions are subject to collateral attacks. Christian versus State, 865, S period, W period, 2D, 198, 201, Texas Appellate, Dallas, 1993, PET referred. Challenge to voidable error in conviction raised on appeal from revocation order was impermissible collateral attack. A void judgment is a void judgment, bill of review and procedural due process in Texas, 40 Baylor L. Revised 367, 378, 79, 1988. C. Thomas, 906, S period, W period, 2D at 262. Holding that a trial court has not only power but duty to vacate a void judgment. A judgment is void only when it is clear that the court rendering judgment had no jurisdiction over the parties or the subject matter or territorial jurisdiction, no jurisdiction to render judgment, or no capacity to act as a court. No capacity to act as a court pertaining to you and I as men and women. Because why? We were guaranteed one Supreme Court. We were guaranteed to be left the motherfucker alone unless they had a warrant out for our arrest, specifically describing the person or the thing to be searched and seized. All right? Absent a federal indictment, you're supposed to be left the fuck alone. Now, I know what you're thinking. Well, they do issue warrants. No, they don't. They issue fucking capiases. Those aren't warrants. Go look up what a true warrant is. When you see and understand what a true warrant is with a proper seal, proper wedding signatures, proper seal of the court, you know, not this stamp bullshit and their robo-signed horse shit that everybody and their dog that works within their little private corporation utilizes to ensnare people and generate revenue that bolsters their retirement. We're talking about real, true bills due and owing. They're actually signed. All right? When appeal is or taken from a void judgment, the appellate court must declare the judgment void. Because the appellate court may not address the merits, it must set aside the trial court's judgment and dismiss the appeal. A void judgment may be attacked at any time by a person whose rights are affected. See Elker versus Texas Alcoholic Beverages Common, 874 S period, W period, 2D, 192, 194, Texas Appellate, Houston, 14th District, 1994. No writ. See also Evans versus Woods Incorporated, number 12-99-00153-CV, 1999, WL 787399 at *1, Texas Appellate Tyler, August 30th, 1999, no pet H, whatever the fuck that means. A void judgment is a nullity and can be attacked at any time. Defiki versus State, number 2-00443-CR, Texas Appellate District 2, 09-14-2001. A void judgment is a nullity from the beginning and is attended by none of the consequences of a valid judgment. It is entitled to no respect whatsoever because it does not affect, impair, or create legal rights. Since the trial court's dismissal with prejudice was void, it may be attacked either by direct appeal or collateral attack. Ex parte Williams, number 73849, Texas Criminal Appellate Division, 04-11-2001. A void judgment is a nullity from the beginning and is attended by none of the consequences of a valid judgment. It is entitled to no respect whatsoever because it does not affect, impair, or create legal rights. Ex parte Spalding, 687 S period, W period, 2D at 745. Teague versus Teague J concurring. Since the trial court's dismissal with prejudice was void, it may be attacked either by direct appeal or collateral attack. See Ex parte Shields, 550 S period, W period, 2D at 675. A void judgment can be collaterally attacked. See Gluns versus Henderson, 908 S period, W period, 2D, 253, 255, Texas Appellate, San Antonio, 1995. Writ denied. Tidwell versus Tidwell, 604 S period, W period, 2D, 542, Texas Civil Appellate, Texcana, 1980, no writ. Finding that a void judgment may be collaterally attacked by a suit to set aside the judgment after it has become final if such void judgment becomes material. We agree a collateral attack is any proceeding to avoid the effect of a judgment which does not meet all the requirements of a valid direct attack. See Glun's 908 S.W.2D at 255. There is neither a set procedure for a collateral attack nor a statute of limitations. See Glun's 908 S.W.2D at 255. That's kind of cool. There's no set procedure for doing a collateral attack in Texas. All right? That's why I read shit like this, so I can start to put it all together. Davis versus Boone, 786 S.W.2D 8587. Texas Appellate San Antonio, 1990. No writ. Collateral attacks may be only used to set aside a judgment which is void or which involved fundamental error. See Glunt's 908 S.W.2D at 255. Fundamental error for this purpose means cases where the record shows that the court lacked jurisdiction or that the public interest is directly and adversely affected as the interest is declared in the statutes of the Constitution of Texas. See ID. The cases distinguish between judgments which are void and therefore may be set aside by a collateral attack and those which are voidable and must be attacked by a valid direct attack. CID. And judgment is void if it is shown that the court lacked jurisdiction, 1, over a party or the property, and 2, over the subject matter, and 3, to enter a particular judgment, or 4, to act as a court. Jurisdiction could not be conferred by waiver of retroactively. Elena Perf et al. Versus Alvin Mazier et al. One of the other things is people are like, what do you mean acting as a court? Okay, your Title 4D venues are family. They call themselves family courts. They're really a private, for-profit organization that are ministerial administrators operating under Title 42 that is not enacted into positive law. It is not a court. It is not a court. It is a simulated legal process meant to look like they have some type of fucking authority where they get a gun-toting moron with an IQ of 70 to stand in the room while people issue idle threats to you because they're trying to ensnare you and get you to agree to give them something for nothing. While they engage in human trafficking, the trafficking of persons, false arrest, false imprisonment, compelling you to be where you don't want to be for a duration of time unknown. While they try to finagle you with an artifice and scheme and device using false and fictitious unregistered names, okay, in a simulated legal process, acting as agents of the government when they're just ministerial administrators operating on behalf of DHHS as private contractors. And one of these days I'll do another course on family courts because they're an absolute fucking joke. And the same thing applies with the DMV, by the way. When you understand the DMV goes into private contractual agreement with the AAMVA, the Attorney General, the Secretary of State, and the Governor of all 50 states, or the BMV, all right? And they go into these private agreements and draw up this monstrosity of bullshit that's all attached to a penal code that has a penal bond behind it, and they're using SF 24, 25, and 25A GSA bonds and 273, 274, and 275 and authenticating your credit into existence. When you finally really understand what they're fucking doing, boy, it will chap your ass. It will chap your ass. Because they're robbing, looting, plundering, engaging in privateering, counterfeiting, piracy, usurping power otherwise not delegated to them. I mean, I'm here to tell you right now that if you go look and research what I'm telling you and what I'm talking to you about, it won't take you but a couple weeks to see it. So when they say acting like courts, that's because a great majority of them are acting administratively as administrative law clerks, administrative law judges, and foreign agents and agency trying to usurp power otherwise not delegated to them on our land, piracy on our land, Title 18, 16, 61 violation, and they're trying to usurp power otherwise not delegated to them and trick you into coming into a foreign dry dock where they can apply their statutes, codes, city ordinances, rules, and regulations on you. That's called domestic terrorism, ladies and gentlemen. That's a breach of trust. That's a breach of their fiduciary duty. That's a violation of their oath. That's domestic terrorism. That's treason. They can be hung for that. But nothing will be done until the American people learn this shit. And this is why they don't teach you this stuff in school. They're a joke, but they're still stealing children. Yeah, human trafficking, trafficking of children. Look, they're bound by executive orders. Executive Order 13818 and 13903. Go hem them up. Because they're all operating under the War Powers Act. All right? The police state. To act as a court, jurisdiction could not be conferred by waiver or retroactively Elena Prefer et al. Versus Alvin Mazir et al. 11/23/1955, 286 S period W period 2D 241. Strictly speaking, a void judgment is one which has no legal force or effect whatever. It is an absolute nullity, and such invalidity may be asserted by any person whose rights are affected. It doesn't say directly affected, generally affected. You can go reverse any fucking decision and make it void at any time. But here's the thing. I say that, but you have to have this knowledge to be able to do it. See, this is why they don't teach you this shit in school. Because if you started reversing all this shit the Bar Association has done to people for the last fucking 100 years, they wouldn't have a pot to piss in. At any time and at any place. It need not be attacked directly, but may be attacked collaterally. So there's a difference between a direct attack and collateral attack. Whenever and wherever it is interposed, usually it carries the evidence of its invalidity upon its face. Okay, on the faces of the instruments, you can literally see where they don't have certain information on the record that needs to be on the record. Once jurisdiction is challenged, it must be proved on the record. They don't just get to orally say, we have jurisdiction because I say we have jurisdiction and we're moving forward. That right there is a denial of due process of law. Anything they do from that point, I mean, you can pretty much just sit down and shut the fuck up. And anything they do from that point is a direct violation of due process of law. You have a right to be fully informed and availed of all the fucking pertinent facts and information, including the nature and the cause. They always tell you the cause. Some benign statute, code, city ordinance, rule, or regulation. They never tell you the nature. That's the swift kick in the fucking nuts for them. All right? While a voidable judgment is one apparently valid, but in truth wanting in some material respect. They failed to disclose material facts. That's a denial of due process of law. That's a wanton disregard for law. That's an abortion of justice. It's a miscarriage of justice. All right? And therefore, it's void. They couldn't clarify their territorial jurisdiction and how they're out here on my land when they're supposed to be bound in a 10 square mile area. In other words, one that is erroneous, such vice may be the want of jurisdiction over the person or other similar fundamental deficiencies, but which vice does not affirmatively appear on the face of the judgment. Billy Duncan, or Dunk Lynn versus A.J. Land, ETUX, 297, S period, W period, 2D, 360, 12/21, 1956, where a void judgment, and this is Texas again, where a void judgment has been rendered and the record in the cause or judgment roll reflects the vice, then the court has not only the power but the duty. It's a duty, and even after the expiration of the term, to set aside such judgment. They're actually supposed to go be reviewing their own shit, making sure they're not fucking up, that they didn't make palpable errors at law. All right? It's a duty for them to go back and review and make sure that they didn't make a palpable error at law and violate your rights in doing so. Harrison versus Whitney. And you want to know why? You want to know why it's imperative that they do that? because when they take their oath, when they violate the law of the land, you can prove intent. Because all men are responsible for knowing the contracts they enter into. That's why ignorance of the law excuses no one. So, did you take an oath? I did. Great. So what you're actually doing is knowingly, willfully, and intentionally violating your oath, breaching the public trust, breaching your contract with intent. And if they proceed on after that, take them to the gallows. Tar and feather their fucking stinking asses. Harrison versus Whitley, Texas, Com APP 6 S period W period 2D 89. This court in Nugent versus Nugent, Texas Civil Appellate Division 270 S period W period 2D 223 followed and applied the rule announced in Harrison Whitley case. The Supreme Court speaks through Foley, Commissioner in Bridgman versus Moore, 143 Texas 25183 S period W period 2D 705 at page 707 said, the court has not only the power but the duty to vacate the inadvertent entry of a void judgment at any time, either during the term or after the term, with or without a motion therefor. We will not extend this discussion further than to state that we here affirm the holding on the point involved as announced by Justice Hightower in the former appeal 301 S period W period 2D 181. While this holding was premature in view of the action of the Supreme Court 304 S period W period 2D 265 reversing our holding, it was not upon the points discussed in Justice Hightower's opinion, but was on the point that since the judgment appealed from was an interlocutory appeal, okay, based upon substantive rights, all right, substantive due process of law, substantive rights, all right, which is your right to a counsel, it's your right to the nature and cause, it's your right to face your accuser. And again, when they're doing in like 98% of the states, I think there's only 3 that do fact pleading. The rest of them all do notice pleading, which means the one that's cooking up the paperwork in their administration side under Maritime Admiralty doesn't even have to swear that anything's true, correct, and accurate and face under the pains and penalties of perjury and face 1 year in jail and a $10,000 fine. That literally means they can just put whatever they want on paper and try and ensnare you into their jurisdiction and get you to voluntarily come in there and claim the stupid name, and boom, they got you. They created a contract with you. So interlocutory, one and not final, the appeal should be dismissed. However, we think our holding then is now appropriate. A void judgment has been termed mere waste paper and absolute nullity, and all acts performed under it are also nullities. Again, it has been said to be in law no judgment at all, having no force or effect, conferring no rights, and binding nobody. It is good nowhere and bad everywhere, and neither lapse of time nor judicial action can impart validity. I mean, this is huge. This is huge right here, guys. And once you've got it declared a void judgment, or once you declared a void judgment, you're challenging them on proving they had all this jurisdiction and shit, territory, in personam, subject matter, all right? The fact that they denied you the First Amendment, the Fourth Amendment, Fifth Amendment, Sixth Amendment, subjected you to the Eighth Amendment, cruel and unusual punishment, simulated legal process, all right? There's a huge fat daddy paycheck on the backside of this for you. And I don't give a fuck if it was from 20 years ago. I don't care if it stems from when you were 16. You can go back and attach yourself to that motherfucking case and make it void and turn around and collect those securities, collect those funds out there. Because once this is a void judgment, you can prove malicious prosecution, you can prove abortion of justice, miscarriage of justice, malfeasance in office. All right? And you can make a claim and get paid. That's why I'm going through void judgments, so people can see how easy it is to go get paid. Also, a void judgment has been defined as one which has no legal effect or legal force or effect, invalidity of which may be asserted by any person whose rights are affected at any time, at any place, directly or collaterally. Black's Law Dictionary, Reynolds versus Volunteers, State Life Insurance Co. 80 S period W period 2D 1087 Texas Civil Appellate Division Eastland 1935 writ referred to Gentry versus Texas Department of Public Safety 379 S period W period 2D 114 119 Texas Civil Appellate Division Houston 1964 writ referred NRE 386 S period W period 2D 758. It has also been held that it is not necessary to take any steps to have a void judgment reversed, vacated, or set aside. It may be impeached in any action, direct or collateral, Holder versus Scott. It's like when you're going against an officer of the alleged law, all right? And then you find out that he doesn't have his Title V 33331 oath of office, his Title V 33332 affidavit in support of the oath of office. It wasn't registered within the 30-day time allotted, and now you've got just an agency running around in a Halloween fucking costume acting like he's Deputy fucking Do-Right. Impeached. Judgment's void. You know how many different ways you can invalidate these cocksuckers? It may be impeached in any action, direct or collateral, Holder versus Scott, 396, S period, W period, 2D, 906, Texas Civil Appellate Division, Texarkana, 1965, writ referring NRE. Washington, court held, this is the state of Washington. I don't believe it's Washington, D.C. Let's see if I see the revised code for Washington in here anywhere. Void judgment. I don't see the Washington revised code. I don't believe this is Washington, D.C. I think this is Washington State. We'll get to that in just a minute here. Is any of this helping you guys? Any of you guys live in any of these states we've already covered? Need help in Western District of Kentucky. I don't know if I got Kentucky on here. Tell you what, we'll come back and we'll do Washington. We're almost getting to the halfway point of this document. And let's see what other states we got. Washington. The next state will be... Wow, Washington's huge. The state after that will be Florida. And the state after that will be... Shit, Florida's a long motherfucker too. Holy sheep shit. Georgia will be after that. Love Georgia's constitution. It's badass. Indiana will be after that. Again, this is all void judgments. Practice and procedures. Then Michigan. After that, void judgments. Then Missouri after Michigan. I don't think I saw Montana on here. Then Nebraska. And what's next after that? Holy shit, Nebraska's got a long one too. Then Hawaii. And that's all the states that it has. So, Wisconsin. Void judgments. Hawaii, Wisconsin, Nebraska, Missouri. And that's all of them. So anyway, when we come back, we'll start again. I believe I was on right here. Washington. We'll start again on Washington. I actually broke down these videos to state by state by state. I do not have Illinois on here. But I got another whole sheet of void judgments from a bunch of other states like New York, Pennsylvania, Massachusetts. Yeah, so we'll come back on. I didn't realize you were going state by state. Yeah, that's what we're doing. But again, understand that you can invoke any of these from any state under Article 4, Section 1, full faith and credit clause. Void judgments are void. I'll look at my other void judgment list of cases and see if I can find Kentucky. Like I said, I've got mountains of this information, mountains of it on void judgments, because I realized really quickly when studying this that that's the largest wealth transfer in the world is void judgments, because they're all void. I would say the better of 90% of them are all void. Once you figure out what they're doing. I mean, you realize if you got a loved one in jail right now and you go and make that judgment void for denial of due process of law, violation of the 7th Amendment, 5th Amendment, 6th Amendment, 4th Amendment, 8th Amendment, and void that judgment, they got to kick him out of jail. Especially if it's a victimless thing. Now, I don't help people that have victims. I just don't. If you were stupid enough to do something wrong to somebody, that's on you. You got some fucking growing to do. I don't help people with DUIs either. I think it's a wanton disregard for life. In the 21st century, you can fucking call somebody. There's no excuse for being all fucked up and being on the freeways, highways, and byways of the people. Come on. Use our heads. No reason for it. So I don't help people with DUIs either. I've done it twice and I won't do it anymore because I believe in karmic retribution. I don't want to get a phone call one day saying one of my loved ones is fucking no longer with us. And all I'll think about is the time that I helped two people who may or may not have changed their ways. And I'll face some type of karmic retribution for it. So I don't deal with DUIs anymore, and I don't deal with people who've caused harm, damage, and loss to other people. If you've done that, go make right with them. And I just told you how to prevail without having to go to court. Go provide remedy. Go make amends. Go privately and say, okay, how much do I owe you? How can I make this right? Where's your medical bills? Whatever. Go make it right. Strip them of their jurisdiction to hear the matter because it's already been settled and solved on the private side. That's all I'm going to say about that. All right, we'll come back. And when we come back, we'll be doing Washington.